Hi, welcome to Boorman Lawyers. Today we are going to look at drink driving offences in Queensland.
Hi, my name's Josh Boorman. I'm a partner here at Boorman Lawyers and we focus on traffic and criminal law. And recently I attended Brisbane Magistrates Court on a middle range DUI or drink driving offence. It was quite a serious matter because the reading was quite high. The reading was 0.135, so it was well up there into the middle range category and just below the high range threshold of 0.15. My client had been out with his wife to an event in Brisbane at the convention centre. Throughout the night he consumed several drinks. They went to dinner and they had pre-arranged a Desi driver service, which is one of those services that can take you and your vehicle home. Unfortunately, it got to a position where the Desi driver service actually said that they weren't able to come and pick him up later on that night. My client found himself in a situation stuck in Brisbane with his car there, and the temptation was just too strong. He and his wife ended up getting in the car to drive home. So those were the facts that were surrounding the incident. And what we did seek to do is put on an application to apply for a restricted work licence for my client, because the subjective features surrounding my client's situation is that he really does require his driver's licence in order to perform his job and carry on his business. His business is solely reliant upon him being able to be mobile and get around to different locations all around southeast Queensland. So it was imperative that we applied for a restricted work licence and attempted to keep our client on the road for the sake of maintaining his job and his business. So what was required in relation to applying for a restricted work licence is we had to attend the first court appearance at the Brisbane Magistrates Court, indicate to the court that our client was eligible to apply for a restricted work licence, and there is a particular criteria that each person must meet if they want to apply for a restricted work licence. Our client did meet that criteria, so that was the step one. We attended court, indicated to the court that he was eligible to apply for this particular restricted work licence. The court took that. The court then adjourned the matter, which gave us about 2 to 3 weeks to put on evidence, such as an affidavit from our client. And he also runs his own business, so basically he was able to give evidence by way of affidavit saying how much he requires on his driver's licence to operate his business and to generate an income for he and his family. That was submitted to the court. It was also served on the police prosecution, along with the relevant Section 87 application forms that must be submitted within a certain time period in order to apply for such a restricted work licence. The matter was then set down into the future. We attended the Brisbane Magistrates Court for the substantive hearing on this application and for my client to be sentenced on the middle range drink driving charge that he had committed. Ultimately, we got a really good result, and what did help that result was the fact that my client did go along and he performed a traffic offenders program, the Queensland Traffic Offenders Program. This is a very well-run 3-week course which anyone can go along and attend, and they learn a lot about driver safety, and it gives them a really unique perspective into the dangers that can occur on our roads from taking part in the offence of drink driving. So he completed that to a high standard, mind you. He received a completion certificate. We were able to tender that certificate before the court, and the court obviously had the relevant affidavits and application forms in relation to the restricted work licence before the court. I was then able to get up and make oral and verbal submissions to persuade the court to deal with my client's matter by way of issuing him with a restricted work licence. We did have to have a look and talk about his prior traffic record and traffic history. Unfortunately, he did have a number of entries on his traffic record. Most of these were speeding related, but I was able to persuade the court that because my client spent a significant amount of time on the road for his job, he was prone to getting these more minor infringements on his record compared to someone who doesn't drive on the road as much as my client did. But there was no significant major drink driving or traffic offences on his history that we had to deal with. So that was quite positive. We did have to explain to the court and persuade the court that my client was a fit and proper person. And this was easier to do, given the fact that he had gone along and completed the Traffic Offenders Program and re-educated himself on the dangers on our road. And we were able to say that now he's re-educated himself on a lot of these important safety issues. He's now a safer and better. He's now a fit and proper person to be provided the opportunity of giving him a restricted work licence. So all these arguments and submissions were well received by the magistrate on the day at the Brisbane Magistrates Court. We obviously did push hard for him to be given the opportunity of receiving a restricted work licence, and the magistrate agreed with us. We spoke to the prosecutor prior to going into the application to advise them of exactly what our intentions were, and they didn't have any major objections in relation to our application. Everything went smoothly on the day. The ultimate result was that our client was provided with a restricted work licence for a period of 6 months, and he was issued with a fine of $1,000. So overall, the main aim of the game was to be able to save our client's licence, and that's exactly what we did, so he can continue working. There were some restrictions put on that licence. A restricted work licence means he can only drive for the purpose of going to and from work or performing duties at the workplace. He does have to keep a logbook, and basically that's it. So he was over the moon, very happy that basically this very big mistake in his life is not going to prevent him from going forth, running a business, employing other people, and generating an income for he and his family. So he can move forward, taking away from this whole experience some very significant lessons. He was obviously very contrite and remorseful, and very happy with the outcome that we achieved for him. So if you found yourself where you have been charged with a drink driving offence in Queensland, in Brisbane or on the Gold Coast, rest assured that we attend all of the courts in southeast Queensland. In Queensland, in certain situations, you can apply for a restricted work licence, which means you can remain on the road with restrictions to your driver's licence. But the best port of call would be to go along to our website at BC. You can check out the Queensland section of the Traffic Law section there. There's a whole heap of information, blog post videos that you can check out to make yourself more aware of the situation you might be in. Or alternatively, feel free to give us a call, ask for Josh. I'm happy to have a first free telephone chat with you, consult with you, to give you a bit more of an idea of the situation you may be in, to see if you're actually eligible to apply for a restricted work licence, or if not, to see what other positive outcomes we can achieve for you. So, like I said, go onto a website and feel free to give me a call.